Hello, everyone. Welcome to Court with Krissy. The quick and crazy court clips that I would normally send to Law Talk with Mike, they're lined up for you now. You're going to love them. So make sure you give it a thumbs up. And if you haven't already, subscribe. Hello. I hope you like it. Court with Krissy is now in session.
Good morning. May I have your name, please?
Good morning. Good morning, Patricia.
May I have your name, please?
Patricia Jones.
And why are you appearing in court, ma'am?
I'm appearing in court because my son is appearing in court for a pre-trial today, a preliminary. Dwayne Jones.
Okay. So the pre-trials won't happen in here. He might Judge Cooney. Yeah. So if he comes in for a plea, it would be with Judge Cooney. And that won't happen for a little while, but the court that you would need to zoom into would be Judge Cooney.
Today?
Right. If you want to see if he's going to plea as a result of a pretrial, then that would be with Judge Cooney.
Okay, we can take that on. Okay, Judge Cooney. Is it, do you need different number or something? On there? Okay.
Okay, so we'll all got there and go to that courtroom. Thank you.
Yes, you're welcome.
Have a good day.
You too. Thank you.
So I wonder if this ain't for us.
And this matter comes before the court for an arraignment on an allegation that Miss Smith Walker violated my protective order that protects Miss Adrienne Simmons. So, ma'am, you're Miss Smith Walker?
Yes, I am.
Very good. I need you to raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right. And Ms. Smith Walker, you understand that if I find that you violated the protective order, I can sentence you up to 93 days in the Kent County Jail for contempt of court, and I can also impose up to a $500 fine. Do you understand that?
Yes, sir.
And if you don't agree that you violated the protective order, then you're entitled to a hearing. I would conduct that likely by Zoom, but also I could conduct it in person in the courtroom at your request. And during that hearing, you'd be entitled to be represented by a lawyer. That lawyer could cross-examine Ms. Simmons and any other witnesses she wanted to put on the stand, and the lawyer could also issue subpoenas and bring in witnesses to tell your side of the story. You understand that right to a hearing?
Yes, sir.
All right. And given that, have you seen a copy of the alleged violation that you're in on?
I have not seen no paperwork at all.
Okay, well, this one, let me take a quick look here. I mean, I've got, because I think I issued this bench warrant back in October, almost a year ago. When you failed to appear, I think I might have got information that you may have been in the Eaton County Jail, and that was
I was in jail. Was it the fingerprints? I'm sorry to cut you off. That's the only reason why I didn't make it to the fingerprint.
I see.
was doing a violation.
That's possible. Well, and then I got a more recent violation. This one is dated this year, and Miss Simmons says I was visiting an associate and she came in and assaulted me, started hitting me in my face. And that was filed on January of 2024. So it's a little more recent than the fingerprint thing. With regard to that violation, do you wish to plead guilty or not guilty today?
I will plead not guilty because I want to, what you said, I can have called witnesses because that's not what happened.
Okay, I'll enter a not
I'm
guilty.
being honest. I didn't even know that was her. She maced me as soon as I walked through the door, so I don't even know who I was hitting.
Who you wound up hitting because you couldn't see anything? You
I don't, because I went to my friend's house. The girl, I'm
well,
sorry.
don't put too much testimony on the record now because
I just want to tell the truth. I just don't, because this is a case that you probably never even had before. Everything this girl say I do to her, she do to me. I went to my friend's house. I walked in my friend's house and I was maced. I'm hitting the air, so if I hit her, I hit her. She maced me. I can't see. I never knew it was her.
well, that
So
sounds
I
like a
think
reasonable.
I feel like we need to take this to a trial because this just need to be seen
Yep.
and heard.
Well, I will set a hearing for it. That's what normally I do in these. And I will set a bond for you. I will make it a bond in the amount of $1,000 personal recognizance. So it won't hold you, but I will warn you, don't have any contact with Ms. Simmons when you're out on bond.
I don't have no contact. I'm telling you, I cannot wait till the truth come out. For this is a case, like it's crazy because everything she say I do to her, she do to me, and there's no way I can fight her because she already have the court on her side. You get what I'm saying?
Yeah,
but now
yeah,
that it
she
was
was
at
the
a
one that
mutual
got the
friend
order.
house, I feel
Yeah.
like we should get subpoenas and the truth should really come out. Like
Good.
this is what I'm happy about, that I finally can state the truth.
Good. And I'll mail you, you're entitled to be represented by an attorney at that hearing. I'll mail you a request for an appointed lawyer if you don't have the funds to hire a lawyer. The address I have for you, Ms. Smith, is on Diamond. Is that correct?
No.
Very good. Thank you very much. We will mail, Wendy, do we have a hearing date to give now?
Sure, we can do November 25th at 9 a.m. on Zoom.
All right, we'll set this for hearing right November 25th at 9 a.m. Via Zoom. And I will send you the documents so you can request a lawyer. Do make sure you get those in so that lawyer can make contact with you so you can present your evidence at the hearing. And I'll hear the case then. And like I say, you know, any even accidental contact with Miss Simmons, just turn around, go the other direction. I understand this case, you didn't even get a chance to see who it was before you got maced. And
that was not fair. We got this. The girl was my friend. That like we got the same friend. It's just I can't wait to go to court.
All right, good. Well, that will be your chance, but you know, even if you do get that kind of accidental, you know, ran into her, you got to go the other direction, like you say, because you're the one that's gonna wind up in the back of the
trouble. I
police
know.
car.
I'm going the other way.
You know the deal. So very good. Well, good luck to you, Ms. Smith, and I will see you on November 25th.
Thank you. Have a good.
Why are you there?
You hablando, right? Oh, yeah, esa madre, beautiful woman with it. Pero era paciencia. Beautiful.
And you are Juventino
Placencia,
Placencia?
the husband, all the beautiful garas, Robert Placencia. And I remember you and I were doing shy.
Ms. Kamari, did you meet with Placencia?
No, Your Honor, he was in a single cell, so I was unable to speak with him.
No,
Okay, well,
it wasn't no single cell. And to, you know, to be totally honest, it's in fucking segregation. I don't understand why here, because when I was over there, and get a video for Myers, this fucking rapos, you know, this fucking made everything into. Why the fuck?
language. Even though you don't feel like it. All right, we'll put Ms. Kamari breakout room. That's it.
And do you have an email address you use?
I do. It's, I'll spell it for you. It's SEXYWIFEY@yahoo.com.
Did you get that whole thing? All right. So would you please spell that back out for me one more time?
It's SEXYWIFEY, sexywifey@yahoo.com. I always feel silly saying it.
At Yahoo.
Yeah.
Okay. Thank you.
Thank you. Good morning. Is it still morning? Good morning, Mr. Williams. Good morning, Mr. Williams. That's going to be my last attempt because it is 11:56. Mr. Williams was scheduled this morning at 10:30. And it's 11:56, just in case you didn't know. Mr. Williams was scheduled this morning at 10:30. It's 11:56. Okay, we'll put him in a breakout room. It's 11:56. It's 11:56. Okay.
I don't need a breakout room from Mr. Williams.
You should, because you should.
Okay.
know that the judge might not even hear your case this morning because it's 11:56. It's
Okay.
11:56. He was scheduled at 10:30. So you might want to ask him, why is he just coming in my courtroom at 11:56?
I've been in, I know if that's what it is, I know, but if there's something else, I'll go back with him.
I mean, I sent him, so I'm ready on
Okay.
that.
Okay.
But what I'm not going to do is continue to wait for Mr. Williams. Case number 194604201, the People versus Dedrick Anthony Williams. Defendant is charged with license plate illegal use. Today is the date set for trial. Appearances, please.
Good morning, Your Honor. May it please the court, Delphia Burton appearing on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Dedrick Williams. Mr. Williams, sir, please say your first, middle, and last names.
Ms. Stevenson, what are we doing here? He was 2.5 hours late for court.
I'm sorry.
Late for court.
Say your first, middle, and last names, Mr. Williams.
Dedrick Anthony Williams. I'm sorry, I couldn't hear you, man.
All right. Today is the date set for trial. Are the people ready to proceed?
Yeah, no, unfortunately, the people are not able to move forward on this matter. There was the case was supposed to be reassigned because the officer in charge was not no longer there.
Oh, okay.
And yeah, subpoenas were sent. Involved the use of a dealer plate. That was the allegation, and it's from 2019, and so we're not able to move forward.
Your Honor, we would apologize to the court for our tardiness. Unfortunately, Mr. Williams found himself arrested and had to walk from the jail. He's back at home now trying to get to the urgent care. We would move for dismissal, Your Honor.
All right. The court is going to grant defense counsel's motion to dismiss as the people are unable to proceed. Today is the date set for trial. The witnesses have not appeared, and it is 12:34. So we will mail a copy of the order of dismissal to you for your records. Anything further with respect to Mr. Williams?
Nothing from the people.
Nothing on behalf of Mr. Williams. Thank you, Your Honor.
All right, Mr. Williams, I hope you feel better. Have a great day. Stay safe.
You too, man. I'm sorry for being late.
I accept your apology. Sound like you had a decent reason.
I did, ma'am.
All right. All right. Bye, Ms. Stevenson. You brought me out there today.
Victor Grebeniko. Start recording.
Mr. Grebenikov, we're on the record in case number 24-3133 SM. You are appearing for
Siri, start recording.
You're appearing for arraignment purposes this afternoon. You're appearing with Mr. Hubble, the defense attorney available through the Indigent Defense Council here to assist you. Mr. Hubble, did you have opportunity to review the allegations on the complaint, the nature of the offense, and the possible maximum penalties with Mr. Grebenikov?
I did, Your Honor. Given the fact that English is not his first language, he is requesting that the court review that same information with him so that he fully understands what the nature of the charge is and the maximum possible penalty as well as his rights. He has advised me that he intends to plead guilty. I want to make sure that he's fully apprised of his rights. I also understand that he's on probation for a home invasion offense, and if he pleads guilty, that's potentially a violation of his probation on the home invasion case. So just want to make sure that the court goes over all that information with him before accepting any plea.
So, Mr. Grebenikov, can you understand me?
Yes. It's
So,
very simple. It's very simple question.
Yes. In this case, you're charged with one count of trespass. The allegation is on October 7th, 2024, that you did enter the premise of the Del Mar Hotel after having been told you were not allowed to do so by the owner of that property or the legal agent. So trespass is a misdemeanor, and it carries with it a possible maximum penalty of 30 days in jail and/or $250 fines plus costs. As this is a misdemeanor, you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty would be entered by the court. You may have the right, you do have the right to a trial, and you have the right to have the assistance of an attorney. You could have an attorney appointed at public expense if you are not able to hire an attorney on your own. You may have to repay the cost of that attorney. If you have a trial, you would have the following rights: to call witnesses to speak for you at trial. You might get an order signed by the court to require those people to come to court. To see, hear, and question all witnesses against you at trial. To be a witness for yourself, or to remain silent. And if you choose to remain silent, the prosecutor may not comment on your refusal to testify. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. If you plead guilty or no contest and that plea is accepted, you'll waive all of those rights that I just told you with regard to the trial, because you won't have a trial. You have the right to be released on bond if you're now on probation or parole and you enter a plea of guilty, or a finding of guilt is made by the judge or a jury. It may result in a violation of your probation or parole. You can be sentenced to jail plus fines and costs, and I've told you what the mandatory maximum penalty is. Do you understand those rights that I've described to you?
Yes. I plead guilty.
Choose. Okay. If you choose to plead guilty, you're going to waive the right to the trial. You'll also waive a right to be represented by an attorney because Mr. Hubble will not be there at the plea with you. So you understand that?
Yes.
And you would face that possible maximum penalty that I described. Do you know that?
It's 30 days.
That's maximum possible penalty. Yes, sir.
Yes.
So I will get the file to Judge Cooney. I don't know when he will be available to accept your plea. You will be remanded to jail until the time that the judge is able to accept that plea. And so for right now, Mr. Grebenikov, you are all set.
Your Honor, thank you. Have a nice day.
You're welcome. You as well.
Love you.
Gage Skippergosh.
Jonathan Baber on behalf of Gage Skippergosh.
Right. Mr. Skippergosh, can you hear me?
Yeah, can you hear me?
Yep, I can.
All right.
All right. And Mr. Baber, how would you like to proceed?
My client, Gage Skippergosh, would like to take advantage of the plea offer from the prosecution. My client will be pleading to disturbing the peace. In exchange, the prosecutor would be dismissing the domestic violence charge.
That is
Ms.
correct,
Brooke?
Your Honor.
Okay. All right. And Mr. Skippergosh, is that how you want to proceed?
Yes, sir.
Okay. If you'd raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, on, let's see, September 30th of this year, were you involved in an incident that took place in Otsego County?
You said that September?
I think that's what it was, September 30th? That's what's
Yeah,
stated.
that
Okay,
sounds about right.
last day of September. Was that incident in at least a semi-public place?
Sort of. It went outside because I was trying to get my boyfriend to leave, but it made it outside, so I suppose.
Okay, and did it cause a disturbance, a public disturbance?
I would say so, yeah.
All right, Ms. Brooker, Mr. Baber, are you both satisfied as to a factual basis?
Yes, Judge.
All right.
Verify the PAC code, please.
All right, Ms. Brooker, do you have the PAC code for this?
It is MCL 750 point, I think it's 167, but give me 1 second to pull that up. It is 750.170.
Thank you. The court will accept the plea to count 2, disturbing the peace pursuant to the plea bargain, will dismiss count 1. Ms. Brooker, any comments concerning?
No,
sentencing?
Judge, I don't have anything to add. I know Mr. Johnson is here, the victim, but I don't know that he wishes to speak or not. I don't oppose the court just doing fines and costs on this case.
Yeah, I can speak if you guys want to hear it.
Well, go ahead. You have the right to speak on this.
Yeah, Your Honor, can you drop that no contact order between me and Gigi because
Well, it's going to, this will just probably be fines and costs, so that means there won't be probation. So the case will be done. That means the no contact provision is not there any longer. It'll be gone after today.
Okay, sweet. That was the only concern I had.
Okay, all right. Thank you. Mr. Baber, any comments?
Yeah, Judge, this entire situation with Gigi stemmed from alcohol use. Gigi's actually checked herself into rehab on her own. It's not court ordered. She's in for 30 days and it could be extended up to 90 days based upon her insurance. She's taking good steps, Judge. And this, like I said, this whole situation where she was loud with the police and got in a fight with her boyfriend, it stemmed from alcohol use, and she wants to get that under control. And I applaud her for taking the initial steps to getting that under control.
All right. Is there anything you want to say before I go ahead and sentence you?
I apologize for my actions. It was very out of character for me not only to be acting like that, but I care about
Travis Johnson very, very much, and I apologize wholeheartedly to not only the court system, but to him and my family as well. This will never happen again.
And you've taken a very positive and affirmative step by placing yourself into rehab. That's a good choice. Be sure to follow up on it. And the key is whether you continue it after you've completed the program there. I hope you will, but I'm looking at this as just, as I said, just a fines and costs situation. And they will total $365. Are you able to pay that today, or will you need some time?
I'm gonna need some time, Your Honor.
Okay, how much time? How much time?
If the court would grant it to be within 30 days of release from treatment, because we don't know if she's going to be in for 30 days or 90 days based upon the recommendations, Judge. So I'm just asking for, if we set it for 30 after 90, that would definitely give her time. But I know that's a long time for this court, but that was my only concern, is depending on how much time she's in rehab.
What I'm going to do is give you 60 days, ma'am. But if you're still in rehab, simply call the court and we'll extend that. Because I don't want it to interfere with your treatment there.
All right.
So do you have a pen handy? And I will.
Yes, I do.
989.
1 moment.
Sure.
989. All right.
Okay, very good.
All
Thank
right.
you very much.
Yes, thank you.
Ashton Blackford.
Let's state your full name for the judge.
I can't hear if she's talking.
You have to speak up.
Okay, you still live on?
Yes, but what is this matter about?
Well, you're arrested for drugs and also for providing an untruthful name.
That's not correct, sir.
Okay, but let's start with your address before we get to that. Your address. I can't hear you.
No.
Okay, what is your address?
I'm not sure anymore.
Okay. Are you homeless?
No, I'm not.
You just don't know what your address is then?
I just got back to town,
Okay.
just barely, and I was driving someone else's truck.
Okay,
None of that
ma'am,
shit, and that's
yeah,
totally
no,
fine.
we're not
I
gonna
don't have
talk over each
truck.
other. You can't talk over each other. I can't hear details of the case now. It comes at a later time. Okay? Do you have an email address?
Your Honor, I was wrongfully arrested.
Okay.
I do not have a warrant out. And so, no, I was wrongfully arrested, and there's no drug charges, there's no nothing.
Okay. Well, you're charged with dangerous
I need
drug
to be
possession or use, and also failure. One of them's a misdemeanor, one of them's a felony. You have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing and an arraignment on the 14th of August at 4:00 p.m.
Oh, Your Honor, I need to be released.
The preliminary hearing is for the felony charge. The misdemeanor charge is an arraignment. When you're released from custody, you have some conditions that you must abide by. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona. Do not possess or consume any alcohol or drugs without a valid prescription. Do not possess any firearms. You have pending matters in the Gila County Superior Court, and being that you're arrested on felony charges,
That's gotta be my twin sister. That's not me.
that means that there's a no bond. You'll be held in custody with no bond until you appear for the charges to the Gila County Superior Court. Can you afford to hire your own attorney, or do you need an appointed attorney?
I have an attorney, Ron Brigida,
Okay.
and I didn't have a warrant out. I was wrongly arrested, and you guys must be confusing me with my twin sister.
Okay, well, they have it down with your name and date of birth, so the
Yes, that's
the-
identical twins,
the
Your Honor.
Superior Court
Identical
will,
twins.
the Superior Court will be able to resolve those matters when you appear in front of
Your
them.
Honor, I need to be released. It's my identical twin. There are two of me.
Okay, well, in the narrative that was provided, they also found, drugs in the vehicle that you were in your.
What drugs?
Dangerous drugs, methamphetamines or something to that sort.
No, still, it doesn't matter.
Well, that's the allegations.
That's not my truck.
That's the
Ron's
allegations.
truck.
All right, that'll be all. Thank you. That's all.
All right, Judge, thank you.
Yeah, we'll send it to you.
Okay, thank you.
You bet. Have a good day.
Mr. Brooks, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. Kenyatta Antoine Brooks, you're before the court on 2024 CR 03695. You're represented by Attorney Morgan Evans, who's with the law firm of Lister, Holt, and Dennis. You are before the court for driving on a suspended or revoked license, no license, traffic violation, obstruction of an officer, and marijuana 1 ounce or less. Ms. Evans, what does your client plead to the offenses before the court?
On offense 1, no cross. Offense 2, guilty. Offense 3, nolo. Offense 4, nolo. And offense 5, no cross.
All right. So by entering the pleas of guilty and nolo, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Brooks?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, Your Honor. The factual basis in this case is that on April 15, 2024, Officer McDonald conducted a traffic stop on a black Toyota RAV4. The officer had initially observed the driver exit the racetrack and cross onto Forest Parkway, and then conduct a U-turn when there was a sign posted, "Do not enter," which is the basis for the traffic stop. The vehicle slowed down but did not pull over initially. They slow rolled until they pulled into a Family Dollar, and then the driver then took off on foot. He was apprehended a short time later, and was observed by another officer throwing something in away from where he was apprehended, which turned out to be what appeared to be marijuana. The officers did make contact with him, and he stated to them that he ran because he knew he had a warrant. And they looked up his information in their and through GCIC and saw that his license status was revoked and he had valid warrants out of Gwinnett County and Clayton County. He was actually taken to the hospital for an injury that was occurred while he was attempting to escape. So he didn't go to jail that evening. The state's recommendation is to dismiss count 1, he's pleading to count 2, to 2nd and 5. So the state's recommendation is 12 months, 10 days to serve with credit for time served. The balance probated to pay a $1,000 fine, but he's been in custody since April 16th, so the state's going to suspend the fine. As well as the fine on count 3, which is $100, and the fine on count 4, which is $300. Count 5 will be dismissed. That'll close his case, but I do believe he's being held on other felonies.
Ms. Evans?
We accept the plea.
All right. So, Mr. Brooks, you're the definition of riding dirty. You didn't have anything right on that day. You had outstanding warrants. You had no license. Your license had already been revoked or suspended, and you you had a traffic violation and then you tried to elude. Sir, get yourself straight. You're too old to be dodging police officers and running from the police and running from your responsibilities. If you did something wrong, deal with it and get yourself straight. How old are you, sir?
I'm 45.
Yeah, no, you good and grown. It's time out for all of this foolishness. You too old to be running from the police. I'm just gonna be honest with you.
Yes, ma'am.
Okay, so start acting like a grown adult who wants to live out the rest of their life with some semblance of something good happening. Because otherwise, you just wasting everybody's time.
Yes, ma'am.
Okay, all right. So I'm going to accept your plea of guilty to count 2. Counts 3 and 4 will be nolos. I'll sentence you on count 2 to 12 months to serve 10 days credit for time served. Balance probated for you to pay a fine in the amount of, no, I'm sorry, balance suspended because the $1,000 fine will be suspended. On count 3, which will run concurrent with count 2, it's a $100 fine suspended. On count 4, which will run concurrent with count 2, it's a $300 fine suspended. And both of those fines are suspended for credit for time served. Mr. Brooks, think about your life. You're 45 years old, sir. This is how you want to spend the rest of your life? Because there are people who still going to jail on a regular basis in their 60s and 70s. And them jail cots don't favor old bones.
Yes, ma'am.
All right. You can go back with the sheriff's office.